And from the very beginning, you need to include your DPO, in the very process. So when you are starting designing your business model, how you will collect data, what you will do with this data, you need to consult your DPO. This was definitely just very uncommon, even for legal folks when you want to include in the company, for the compliance of commercial strategies and business, but nonetheless to the privacy matters. Also, what is important for some companies, you need to do privacy impact assessment, which is one of the most challenging things I have to say today, because the companies need to really, see what are the risks, what are the implications, and to weigh these two, and to present, and to vary, and, all these things that we are doing are not presenting, the high risks for, violation of right to privacy and right to individuals. So pretty much you do not have, some pattern that you need to fill or checklist, but you really need to go deeply into this process and to really think what you are doing, how you are doing, and how this is affecting individuals. And on the very end, to demonstrate all this in this document, like privacy impact assessment. So for me, these are, let's say, some from the very practice, the most important implication on the data controllers and data processors, but I would really like to hear from all of you what are your concerns. Yeah, please.
Sorry, do I have to?
Yeah.
Okay. Thank you. I'm Elisa Stamo. I am a participant from Albania, from the National Electronic Certification and Cybersecurity of the authority. So what is my concern is that, okay, we passed the law, we implement that. Do I have to speak like this?
Yeah, I can hear you.
Okay, sorry.
They are hearing you, just like make it closer.
Okay, thank you. So my concern is that as an authority that I'm supposed, since Albania is not yet into the European Union, but we have implemented the direction as it's supposed to be implemented. My concern is how I'm supposed to control those, how they are implementing the law that I already passed. This is my problem, that we have made a list of, let's say, critical infrastructure, which the companies mostly are banks and issue top for us in this moment. But how I suppose if they are applying those, I'm as an authority I can go and control and everything, but I'm allowed by law to make a certain control on this data. The problem is, up to what point I can check that they are okay with all the topics, the control, because business anyhow they are supposed to be, and how I'm supposed to connect to because European country individuals are working in Albania, and I'm supposed to implement this right the way it's implemented in Europe. I'm doing this for these individuals, but I have to do also for the other ones, which I already have there. So these are some of the topics that I wanted to check according to your information.
Well, in my personal opinion, I first think that what kind of powers you will have as the authority will pretty much depend how you drafted your legislation and what are your authorization with respect to the concrete company. But how you will control and to what extent, I agree with you, most of the countries started from this, which are the biggest company who are collecting the data, like the banks and telecom operators, etc. You mentioned, so it is quite clear. But I don't think that the point of GDPR, was to have that much control over the very subjects, corporate subject. I think that the point was, hey, folks, let's self-regulate. Here are the rules, try to implement. And if you see that, GDPR is asking from you that your processors be compliant, the very corporate companies, controllers or whatever in the chain, which want to be compliant, have the high level of corporate culture, will force their processors to be compliant, because they will say, I will not cooperate with you if you're not compliant. And you need to certify this to me with signing the data processing agreement, where you will specify in details how you process data, what you do, which technical organization measures you implement. So pretty much I think that when GDPR starts, living into the full extent, the very companies will force one to each other, into the very chain to be the GDPR compliant. That will pretty much easier the task of national authorities, because I think it is unfeasible and impractical to expect from one authority how many people you have, I don't know, to, have the full control over all corporate entities. That's not the case in other areas, more traditional like tax or something like that, nonetheless into the privacy, But I think that this, chain that will just develop when one company starts to be compliant, forcing their business partners to be compliant, will the biggest, motivating pulse for everybody to be compliant. And in the bottom line, you will in most cases react, you have some list of the primary companies that you will check for sure. But in the essence, for everything else, you will pretty much react upon the notification of anybody who is complaining on the behavior. So that would be your trigger, in my personal opinion, because I don't think it's feasible, from the authority to expect to, have full oversight over the whole operation of corporate entities. Yeah, this will, for sure, even this will be challenging, to dig into the, big companies that you have on the list and to see what they're doing, or even to react upon notification. But pretty much I think that when the practice, everything start, living and everything start going on, when the data subjects start approaching you, you will see from their request what are their concerns, which they have in the company and what to look for. That's my opinion. Anybody? Sorry.
Hello, my name is Elena Yurkina, and I've been working as a lawyer for the European Court of Human Rights. I was also working at the Council of Europe, and today I'm representing a law firm. We advise a lot business on various aspects related to internet. And so here I would like to raise some questions I faced in connection with the GDPR. First of all, I should say that in Russia it seems that it is a little bit misrepresented and misinterpreted, because there are some information about the GDPR and the requirements, which from my personal view, are not correct. And this is maybe a problem of interpretation, and this put in stress a lot of small businesses, which think that a huge burden are posed on them in relation to GDPR. To illustrate, for example, one fund raised, they've been sending out newsletters for 10 years for particular clients, and now they have to stop this practice because they don't have the proper consent which is required under GDPR. And nobody understands that the main question is that it is related to, not to European citizens, but to person located in Europe, which is very difficult to understand who is located, who is not. So basically in Russia, GDPR should be applied more or less to if the company has international business or at least some international clients, it automatically applies. And this put in stress because in Russia there is special personal data regulation, which at some point might also conflict with the GDPR. And the main question is there is a Yarovaya law, which says that all communication should be kept during 6 months, and metadata should be kept during 3 years. And the question is here whether apparently there is conflict with GDPR, which says that, of course, the data can be stored for legal purposes, but whether Yarovaya law in Russia is a good legal purpose for GDPR and European authorities. This is my first question, how to interpret this, because otherwise the company is already saying that maybe they will be forced to leave the European market because of this, if the Yarovaya law will not be understand as a due legal requirement. And The second question is what is the relation between the blockchain technologies and personal data? Because in blockchain you cannot delete information. Also under the GDPR you have to keep information for the certain period of time, and then you have to get rid of this. And I also don't understand how it will be work. And my third question is about transfer of personal data, because under GDPR you cannot transfer to third countries if they're not considered to be good. On the other hand, we have the Council of Europe Convention 108, which was recently amended on the 18th of May, and it says that the data can be freely transferred to the countries signatories to this convention, which in my opinion, maybe I'm mistaken, correct me if I'm mistaken, but in my opinion the personal data can be freely transferred without any special consents within the territory of all 47 member states of the Council of Europe. Yeah, and so these are my main questions I would like to raise today.
Okay, yeah. Yeah, we have a remote question.
Yeah, we have a remote question from Amalie de Silva, Michel Yuki. Management consultants and accountants in particular are developing GDPR data management application processes as a part of their professional area or of practice.
Okay, thanks. Well, I should briefly first refer to your questions. As you said, well, the problem with the interpretation is GDPR is not, I think it's a common problem for any country. It's not only the Russia. For me, GDPR, it is really great first step to regulate the issue of the privacy. But as all first steps, it is the first step. So let's be realistic. This is something that will need to be further developed, that will need to be interpreted according to the practice and the development of technology. When GDPR started to be drafted, I think it was in 2012, if I'm not mistaken. They need how much? 4 years? Do you know? Sorry. Yeah. Yeah. Okay. Yeah. Okay. They need, few years to develop GDPR, and during that time, technology even go further. New business models emerge, as you mentioned, the blockchain. And today, it is the biggest concern how you will implement the GDPR to the blockchain, and I don't see clear answer, at this stage or this point, So that will be something that will be, further elaborate in the practice. I think that I read recently that even in Austria, I don't know if anybody is familiar, they have the new legislation that pretty much with interpretation of who are, to who you apply GDPR, it covers the business entities, which is quite absurd, So that's how you see that some things are not, still seen how to be applicable in the practice. And I think that we will now need to see how we implement all of this, and to see what are the obstacles, the burdens, and to see what is, implication for GDPR to every business model in order to say, okay, we need this to adjust, And also when you read the GDPR, you will see that in many places you have like, limitation, that some things will be done if this is feasible, if this can be exercised. So from the very tone of GDPR, you still see that there is recognized need that this needs to be implemented in the very practice, and to see how everything, will go on. As for the burden on the small companies, also the key issue in every country, because the first are the small companies who really raise the voices and, hey, this is too big, compliance effort for us. We don't have money and we cannot do this, and, this is tough our business. But from my point of view, I think we should really ask the question, what is the small company? Do you think that the small company is somebody who is doing, gathering all the data from many sites through many surveys, or selling the products online, and who has maybe few employees, because most of the things is done based on some algorithms or thanks to some software, and maybe has a really big turnover. That's why I think that we should really try to redefine what's the small and medium enterprises in the sense of the digital economy, because it's not really the same as in the traditional, economy where we learn to measure the size of the company by the number of employees, by the size of the profit, and etc. For GDPR, you see one a risk approach and risk balanced, in the very text, where you are pretty much looking what are you doing with data, how much data you have, and that's, how big risk you pose to the question of privacy. That should be the primary criteria for you to see whether this compliance is really big burden to you or not. Because, for example, if we were talking about the company that is producing food or something like that, I think you would all agree that it would not be, fair to say, okay, let's exempt small companies from going through the food quality process because they don't have money to do, compliance with the food quality process. I think that's the same ratio that we should apply here and think what the companies are really doing with our data. What is their business model when we, talking about the small and the big companies? And I'm not sure what was, sorry. Yeah, as far from transfer, my colleagues in the other groups are elaborating that question, but I really agree with you because the convention one, it was pretty much stating that you can freely transfer the data between the countries, and now you have the conflict with the adequacy decisions that are listing only the few countries, and for all other you need the permission, or some other instrument to transfer the data. And this is definitely one of the topics that is still not, elaborated to a certain extent, and it will need more interpretation in the practice. And as far as from the moderated questions, if I understood well, the question is, it's not a question, it's most comment. Yeah, definitely the comment is what consultants and accountants is, they are developing certain data management application systems that really become popular nowadays. You can see OneTrust and many other providers that are, providing you with certain solution of how to, be GDPR compliant. But the essence is that with GDPR, you have a lot of, let's say, paperwork, to prove your records, to prove that you, that to see your policies, to prove that you are exercising rights, to record whoever righted you with respect to this and that, how you responded to this and that, whether you are deleting data after a year or two, how you will, implement to, if you are selling goods online, to on each user delete the data, for example, after 2 years, if we buy goods every day, so you have the contracts, starting from different periods and etc. So pretty much, there are definitely many new tools that can be very useful for these bureaucratic things, let's say. But that's only as much as you see, like you have contract management systems in the companies, that's pretty much the same thing, with GDPR. It is useful and handy, but in essence, it is not making things done. You need to design everything and to just put into the system that will, just do the bureaucratic work instead of you. Okay. Yeah.
Thanks. There's a bit of comment about Russian specific in. My name is Andrei Sherbovich. I represent Moscow Higher School of Economics, Law Faculty, Department of Constitutional Law. I'm dealing with the human rights of Internet users, making a legal research. There are principal difference between the GDPR and the other measures on human rights protections, for example, applied in Russia. For example, as I know, it's my opinion, it's just my opinion, that Russian legislation on personal data has no purposes for users' rights protection. It has purposes of, I think, a kind of political reaction towards external political things. As far as nobody could call EuroDiG law as the instrument for human rights protection. It's a very harsh, restrictive measure. You couldn't even compare the level of human rights protection in Europe and in Russia in particular. So that I think if the GDPR will be applied in Russia, it would be a real purpose of human rights protection. It has, I'm not dealing with particulars, for example, for impact on businesses, impact on this and that. I'm dealing with, for example, maybe infrastructural things on the website, for example. If the website is not compliant with the law of personal data protection in Russia, it could be blocked. Like the LinkedIn.com was blocked in Russia due to incompliance with the this personal data. It's an instrument to close websites. It's not an instrument for protection of rights. It has another, principally another purpose. And so we have to understand this information as a kind. But also have a small illustration from some groups of people. You know, all our airlines have no notifications, including the Aeroflot. Russian Airlines has no notification of changing their personal data policies due to enactment of GDPR. And people in Russia are thinking that, why? The Aeroflot is not European, it's Russian company. It should not be compliant with the okay. They even, some people, I think from patriotic, so-called, I think, patriotic part of the Russian internet, you know, some users, they say, let's stop flying to Europe when not to comply with the other, it's infringement of the sovereignty. So, you know what the talks are happening now in Russia, and I don't know exactly what to do. When people would like to infringe their own rights for the sake of one so-called sovereignty, I don't know, it's not a real sovereignty, it's so-called sovereignty. When because I believe they are not absolute sovereign states. All states have treaties and negotiations between, and they have obligations of human rights protection. It's okay. So that is exact situation we have in Russia. What's happening. And next step is the enactment of the second part of EuroDiG law, when they have to read they have to store every single message of user for the 6 months with the possibility of transferring it to the security services. So that it's starting from 1st of July. Thank you.
I'm Martin Mlinar from University of Economics in Bratislava in Slovakia, and I'm curious to know that, like, GDPR is amazing, but the real practice in Slovakia is that many small companies have no clue what they should do, and they are becoming victims of maybe law firms or some other advisors who are selling them documentation, and they don't really know what they need. So they're paying thousands of euros for basically some papers, and after all, they're going to have a notepad or folder of documents, and they're not going to apply anything into practice. So I guess that maybe some education is needed and required to explain people and explain businesses that it's amazing that you paid for documentation, but that's what you really need. You don't need to comply with all the things if you just store maybe like invoicing data or some phone numbers. And if you don't deal and don't sell the information, it's much less than if you work with all the data. But like, they don't have to pay for all the things, and they should know what they should do after all, you know.
Just a very small comment. I would totally agree with you, because what I faced is that some clients, they received different pieces of advice from different law firms which were controversial. Nobody really understands what are the rights and obligations of the party of controllers and processors, and the question of provision of more information and explanation is a topical question, I think.
Okay, so a few quick comments. So I think basically what everybody who's on the map has done has gone for kind of minimum viable GDPR compliance, MVG. And basically, a lot of this stuff should have been done during the earlier legislation as well. You should know what you are doing with the data, but since the earlier legislation didn't have teeth, then everybody was like, well, we have so much other stuff to do, so let's not bother with this one, because the consequences, well, there kind of are none, really. Just maybe some loss of reputation or something teeny tiny thing, but nothing really serious hitting your profits. And I guess if you have done, and if you know what, where, why, when, who, and how, the traditional question set, who's doing what with the data, how are you processing the data, what are the reasons you have the data for, then you're pretty well prepped at the moment. But of course, with the GDPR in force, it doesn't mean that the work ends now. You need to maintain the information, and that's the tricky part. And you will want to develop further, or at least in the company I work for, we realized that, hey, this is the kind of minimum viable thing we can get done now, but we really want to do this better. So that's going to be a huge thing for us, because we have a lot of internal APIs, for example, that we use to process all kinds of information internally. And then we realized that, well, over the years, these have become a big, huge tangle. So we really need to untangle the whole thing. And I guess real world examples and interpretations will start coming, and we will all see how those really work out.
Can I ask? I have Julia from Ukraine. I presented their mega security service company. It's a company which provides cybersecurity, different services. And we have some problems because we not clearly understand who can check if my company complies with GDPR or no. I mean, okay, it's understandable that people can go and ask how you processing my information, information about me. But which other company can go and ask to you compliance or not, and if we doesn't compliance with GDPR, for who we need to pay money? I mean, that's my question.
Yeah, just to briefly elaborate, everything, because we don't have that much time. I will just refer to your point and what is most important. Yes, GDPR started from a few days ago, but the privacy and data protection is something that was developed much earlier, and it was present in the previous legislative acts. So here is the issue why we didn't pay that much attention to this topic, earlier. And now in 2 years we need, to reorganize everything because we have strict penalties and other things. So I don't think that, yes, GDPR bring new things, but only in the manner how they are structured. You have more clear maybe guidances, you more clear set of rules, concretely what to do, how to do, and you have really strict penalties if you are not complied with GDPR. So that's pretty much maybe the change, because the companies are now really paying attention. But that also brings me back to the question, as you said, that how you know who to certify you, how you know who to trust, which advisors. But that's pretty much the issue, well, let's see from the perspective of the company. For example, when you outsource some legal issue to the law offices, how the legal team know, who to trust or whether your advice is good or not good. But you have the legal department in the company that know which law office is, acceptable according to your terms. You can check it because you are a lawyer. You have the, legal ratio to see if they are on the fine grounds or not. For me, it's the same with GDPR. There is no, quick answer. There are a lot of GDPR consultants, unfortunately, lately, and many of them do not have a clue about GDPR, and they can freely sell, this, let's say, know-how, because internally you don't have nobody to check that, and you are just blindly trusting to these companies because you need to be GDPR compliant. But that's the point that now companies will need to boost, GDPR practice in-house if they want really to focus on GDPR. And for the companies where the processing of personal data is the very business model, for me, this is more important than any other business units, because this is really correlated to your business. Legal and everything, fine, that's great, but this is your business model. You need to know, how to be compliant. So pretty much here you see one compliance area to becoming the part of the business and commercial strategy. That's really important, and that's why we will need, to boost in-house knowledge about the GDPR. And I think that would be the best solution, for everything. But now, of course, in this initial phase, there will be a lot of, things that are not done really according to GDPR and in the best manner, because, that need just to go some time for everybody to be able to check really that somebody is giving you right or wrong advice. And this brings me also to the certification point where, yes, GDPR defines that you can introduce by the national legislation some certification mechanisms for the companies, but to be honest, at least in my region, I haven't heard that that kind of body is formally instituted up to now. I don't know what's your practice in your jurisdictions, but I don't think that this will be very soon, because first we will need to see how to implement GDPR, what would be best way to implement it and to check everything in order to, get accredited body that will be able to certify whether you are GDPR compliant or not. I think that the best approach to this is now that you can hire some audit company which is doing GDPR compliance to go through your records, see everything, give you a report and state here this is okay or not okay, but this is not a formal certification. This is more like, input for you what to do and how. And lastly, on the more political questions from your side, well, I understand what you want to say, that it's going on in Russia with GDPR, but I think that, you know what, if you want to use some legislative tool for the political purpose, it's not relevant whether it's GDPR or something else. We have seen the situations where the media freedom and other, legislative acts were used for the political purposes. So
let's get back to the seats.
Yeah. Mm-hmm. Okay. Sorry.
I have a few questions.
Yeah.
During the discussion.
It is general comment, and I promised him, it's about a staff recommendation from him.
So we'll bring it back now. Okay, we'll have time now for that, so we can read it. Sure.
It's about an outcome of the meeting should be like this.
Yeah, okay. That's a good question. Okay, let's take the seats.
Thank you.
Name is Wonseyev. Take your seats. Get some water. Not really. That was a mistake I forgot to mention, yeah, but.
Claudio, should I start with you so that then you can focus on taking notes from the others? Is it okay? All right. Okay. I'll start with your group. I'll ask you for quick takeaways and then the group if anyone wants to add anything.
Okay. Well, I hope the group work was useful, and I see some exchanges of business cards. That's a good signal. Thanks for the energy, and I owe the apology to the two groups that were in the lobby. They were suddenly kicked out of the lobby because they were too noisy. So some of you had to be in the sun, and I apologize for that. We'll ask for another round of beer or wine afterwards. Okay, so the idea is we have about maybe 20 minutes or something to run through where the groups are. Unfortunately, we didn't have enough time to switch the groups so that you could actually visit more than one group. So it was rather focused. But this should be an opportunity to exchange a little bit of a broader thinking about the topics. So I'll run through each of the groups. I'll first ask the resource person of the group to, within a minute, summarize maybe the main takeaways. And then I'll ask all of you from the group or the others, if you have anything quickly like a tweet to share with us that you either took away as sort of a lesson learned, or a question that might have remained open that we should still discuss. And when I say a tweet, it should be a tweet, 240 characters if possible, but you can also tweet, and I encourage you to do tweet while we are talking. So if you have anything you want, just tweet it using the EuroDiG hashtag. And I'll start with Claudio, and then we'll move on. Claudio.
Right, thank you, Lino. I'd like to thank the group very much. It was a very fruitful interaction. As you said, this is an educational session, but it's also an opportunity for exchange, right? And so a couple of problems were raised. I would summarize basically in two, if anyone from the group wants to elaborate for a minute. The most pressing problems that we find were now this new reality of social media platforms brings much more people to the environment of data protection and privacy. So we need much more awareness and capacity building. We were not able to identify within the group concrete initiatives, wide initiatives of capacity building and awareness in that sense. And the other one started exactly with the question which was posed here by our fellow about the balance between freedom of expression and data protection and privacy issues. We found that the exception of public interest might be an adequate role to address the problem, but we do not have yet in place the adequate mechanisms and tools to tackle that. If anyone from the group wants to add from that, please.
So anyone from the group wants to add anything? Takeaway, a question, something that remained unresolved? Seriously? Good. Such an efficient group. Good. Okay, anyone else who wants to comment on social media and GDPR? Out of the group. Anyone has any additional question that you might like to raise? No? Okay. We had one question from remote, but I'm not sure what was the focus of it. Should we read it now or should we? Let's read it now. It's fine.
Amali De Silva. Establishment of an online resources hub like TIP, particle applications, legal development in short forms, legal enterprise participation, etc. as an outcome of this meeting would be super.
Comment for the outcome, which is quite useful. Claudio, you're taking notes, right?
Yes.
You're trying to. Okay, good. He's going to be the rapporteur of the session, which is interesting task. Okay, we move on. Adriana, you want to take a minute? So just to update us on the data controls and processes? Key messages?
Yeah, as far as from this topic, we have really vivid discussion, much more question than being able to answer in such short notice. But in the essence, everything was going on first from the point of local authorities, how they will be able to oversight implementation of GDPR, because we have, as you all know, less manpower in the local authorities than being able to control all the companies, you know, and to really check what is going on the field. And definitely we saw that one of the mechanisms that will be at least applicable for the time being in the practice is to react upon notifications and to see when you get a certain complaint, in which direction to go, what to check and everything. That would be definitely, at our opinion, the first thing how to handle with oversight of GDPR. Also, there were questions about the problem with interpretation of GDPR in the national legislation, because as you all probably know, in many legislation there are different, interpretation in the national laws, also many misunderstandings, and this is definitely something that will need to be just, cleared through the practice, years of practice, and the best practices implementing from one country to another country. The other arguments were also that there is a lack of knowledge about the GDPR and who to hire to advise you with respect to GDPR compliance when you are the company. but that's also the issue of building, know-how in the companies in-house, where you can be able, to see how to cope with the GDPR issues, because in the essence, data protection and privacy will be one of the core activities in every business model that is based on processing the personal data. So that will be, in my personal opinion, mandatory function in every company that is dealing with personal data. There is also the very good argument about how to prepare for GDPR, because it comes so sudden. But as my colleagues mentioned, the privacy and data protection is not something that is novelty came with GDPR. It is something that existed long, long before. And the fact that many companies were not prepared for it because the corporations were not paying that much attention to the privacy and data protection. And that's why we had a lot of issues lately with the data breaches and other cases, which inspired the legislature to come, and draft the legislation that will really deal with data protection and privacy, with strict rules and strict penalties and obligations, or just to put the issue on the higher level. And that's pretty much, to sum up, everything.
Thanks. Seems like it was not that general. It was quite into details. Good.
Yeah.
Any tweets from your side? Questions, comments, takeaways? Nothing?
Can I?
Yes.
Can I cheat?
Sure. You want to tweet?
No, cheat.
Cheat. Okay. Please do tweet if you wish at the same time. Okay. Moving on, Nana, the role of the data protection authorities.
Thank you. Well, I think Adriana just pretty much answered the question, which wasn't answered in my group. Why aren't we ready for the GDPR? So basically, she said that these multi-million companies, they just do not want to comply. I wouldn't agree that it came suddenly, because as the participants of my group said, the companies had quite time to comply and quite a time to get ready for it. You could have hired someone to comply. And still, the question remains unanswered. Why aren't we ready? And the second question, which was also very important, are the data protection authorities ready? Yeah, that was the second big question. And if someone would love to elaborate on that, someone from the audience, not exactly from my group, for example, anyone, I would be glad to hear the answer.
Thanks. Anyone challenged to respond to this? Probably not. This is something we'll save for the next discussion. Okay. Any other comments on the role of the data protection authorities? Any questions? Any thoughts? Yes, please go ahead.
Roger Begelinger from Switzerland was in the same group. I think one of the outcomes, we did not discuss that, but what came to my mind afterwards is, did the EU really did a good job in explaining to the world at large what the GDPR really means? It is not only about the data protection authorities within the EU, which are probably not ready, but also about the data protection authorities outside the EU who face an even tougher challenge.
Good. There was a comment over there. Where's the roaming mic? Do we?
I'm good here.
Okay.
So my institute has this collaboration with the Turkish DPA, and so data protection laws in Turkey relatively are new. We passed a law like 2 years ago, and I would say that they're struggling a lot because they don't have the resources and they don't have the enough people amount. Even they do so, the people they have is not, well, I think this is being recorded, but they're not qualified enough, if I would say so. So yeah, outside of the EU, this is a country who tries to, keep up with the data privacy laws, but we have a long way to go.
Good, Martin.
Actually, we discussed also this in our group in connection with certificates and code of conduct. And what was suggested is that, it will be impossible for data protection authorities to check if every startup and SME is actually complying with the code of conduct. But a suggestion that was given by a person working at DPA is actually to work on empowering data subjects to be the ones that go to the DPA and and show that, for example, they think the SME is not respecting their rights. So it might be a way to go to actually empower data subjects rather than empowering DPAs to check on everybody.
It's interesting to see the cross-cutting topics through different groups. Good. Any other comment? Tweet? Don't forget to tweet this. Okay. Good. Then we move on ICANN, right? And WHOIS, or well, not ICANN, but WHOIS.
WHOIS,
GDPR.
yes.
Right?
Okay, that was a very popular group in the end. We were a lot of people. We had to move up and down. That was fun. And I would say it was not an educational session, because in the group there were a lot of people who actually know what is going on, are very, very knowledgeable about domain names and the issue at hand. So we kind of took a different approach, and we discussed if we were as knowledgeable about the issue to discuss the problem with the DPA, what would be the core points we would like to point out so as to frame the discussion. Such core points would be that there is no single database. It's a decentralized database, which makes a difference in the discussion. That the enforcement of contracts on the contracted parties has a limit, and it is the local law which always supersedes the contracts that contracted parties have with ICANN. Another important thing is the usages. The usages of the WHOIS today. There is a big discussion whether this is actually part of the mission of securing the stability of the internet, or whether it is just usages over time. Therefore, you shouldn't be caring about them when you are saying which is the purpose for processing. So that's something to clarify to a third person, how these usages link in the end in the core mission. And also we would explain the peculiarity of the community and how it develops policies, and what could be an enforcement issue and what could not be. Okay, then thinking of what we would like to see as main messages from our discussion, we would say that, because there were provocative questions in the group. So we came up with the message that we should care about the WHOIS. It is linked to our duty of care to the internet community as such, but in a balanced way between the privacy and the need for security of the network. And that on the way ahead, because there is a long process so that the WHOIS becomes compliant, we need a clear path forward with respect to next steps, and there should be leadership by ICANN to define the process. I would say that this is pretty much it. Thank you to everyone.
Thanks. And you were quite smart to move into another room, so that was a good idea. When I jumped in, there was quite a good discussion. So I wonder if anyone from the group wants to add anything or comment or open another question that we should continue discussing in future. Anyone from the WHOIS group that wants to add? No. That was pretty much a good summary. Okay, any other comments or tweets on the WHOIS aspects? No? Okay, then we move on. Tapani, the consent, I wonder whether you managed to add a little bit of biometric issues into the group, but probably you didn't have time, huh?
No, I have to say that we rather found out that would have been lots to discuss of this little word. And it was a somewhat rambling discussion, and fortunately Anna volunteered to make notes. I'll hand it over to her to summarize, but those little details we managed to discuss, which is nowhere near all.
So in our group we discussed, we tried to discuss consent, and then we found out that we have still more questions than answers in this group. We tried to see the definition of consent and what's the difference between consent and explicit consent, which is offered in sensitive data article regarding sensitive data. We also tried to think about the ways how the data controller can demonstrate that they had valid consent in online world, and if there are some technical measures they need to use for this demonstration, some logs or something like that. We also thought about what does it mean to provide clear information for data subject, because is it enough to say that we will use your data for advertising, or does it mean that we need to clarify what the process will be behind this purpose? What does it mean? Does it mean profiling or not, and etc. and etc. We also try to address the issue regarding sensitive data and the use of it, and how can it be used if it manifestly made public from data subject. And then the big issue at the end was identification of data subject regarding minors and regarding just in general data subjects. And we had these questions, and I hope we're waiting for best practices and for some other expert opinions. Thank you.
Would one of the conclusions be that you definitely have to continue discussing this strange word of consent, huh?
Yeah, pretty much the consensus was that we could have an entire workshop or several on this very subject.
So the next sexy word is consent. Okay, good to know. Yep.
Hello, Elisa from Albania. I agree with the part of the consent because before you give the consent, you should know that he or she knows what she's giving consent to. So the problem of consent is that we have to make something like a broader information to our citizens that what we are consenting to, or at least know for what those data will be used. Can we know that they are being protected and being used for what we consented? That is my problem right now as an authority. Sorry for the
thanks for question of how to implement it, right?
Yes.
Yeah, we discussed precisely that for quite some time. How can we tell, what can I explain, what detail has to be given on how it's processed, what are you consenting to? And that's a difficult question.
Thank you.
Okay, that can remain as one of the messages to discuss further, right? Good, sounds good. Anyone wants to add anything? Yes, Jacob.
Yeah, not to contradict what the reporter said from the group, but to integrate. I think that there was an important discussion about the child-specific issues, and there is a specific problem about age verification, and there is a need for research on the age verification tools that at the moment are not really developed, and nobody is investing money. Probably there is need for public money to be invested in that area, because at the moment the private sector, for understandable reason, doesn't want to go very much in deep in this. Thank you.
Thanks. Any other comment?
Yes, thank you. Just to add briefly, I think it was a great development that we had the consent and the human rights aspects combined in our group, because I think the consent issue is where users' rights prominently come in. It's where users really implement their right to be informed, and one way to tackle the issue, how to deal with this, that before users give their consent, they must really read the conditions and everything, is empowering users, which has to do with media literacy, digital literacy, and that has been something where states must invest a lot, as well as companies. Thank you.
Thanks. Good message also. Someone tweet, please.
Yeah.
Okay, Martina, at the end. There is another one, sorry.
Yeah, just to briefly add, we also talked about a situation whereby you're trying to sign up for an online service, but you're asked to either give your consent or denied service. So in such situation, is that really consent, or is it forced consent? So it led to a very extensive debate.
Good, thanks. Note taken. Okay, Martina.
Yes, so in our discussion, we had the first part of the discussion about GDPR, Chapter 5, and then we spoke about Council of Europe, modernization of the Convention 108. So I'm going to talk about the first part, and then Peter about the second part of the discussion. And we also agree that there are more questions open now than there were before we started discussing. First of all, about adequacy decisions, I think everybody agreed that they are very political, and that's not necessarily a good thing, that these decisions are politicized to that level in the EU. We also spoke about how are we going to do with adequacy decisions that were implemented before GDPR until they are reviewed again by the Commission. Are they still a basis for transferring data abroad, or or not, and what about Privacy Shield? We all know that like it might not really still provide adequate protection for the consumer. So what about it? It's still an open question. We also talk about the fact that we speak about protecting data when it's transferred outside the EU, but what about the protection that data gets from when it comes from outside the EU in the EU? Are our member states protecting data adequately and not doing what, for example, the US is doing? It's another open question. About certificate, code of conduct, new certificates for transferring data abroad. The discussion is still open there. How do we want this to be shaped in a way that they don't become like a fixed certificate like ISO, and companies do not keep up to date with privacy and how to make sure that privacy is protected? And also, the point about DPA is like if we have like certificates on code of conduct, how can we make sure that DPAs make sure that companies are still complying with this code of conduct over time and not just when they get the certificate and then just not doing it in the long term? And about the Council of Europe.
Yes, thank you very much. Certainly there are open questions, but from the Council of Europe point of view, the Convention 108 can bring an appropriate level of data protection, which can translate to an EU language as an adequate level of data protection for third countries, which is very important, and that is what we are promoting in our organization together with other instruments as well. From EU perspective, the Convention can be looked at as an external leg of the privacy acquis, if I can say so, which will comprise GDPR directive and the case law together. So because it's much more than at the EU than the mere GDPR. And we looked briefly into a case example. For instance, in Tunisia, if we are doing business in Tunisia, which is a Convention 108 party, but not a member of the European Union, but we are dealing with European Union, there is certainly a question of enforceability or extraterritoriality of the GDPR, which is again an open question, and we didn't discuss that, but that is it, more or less. However, with the Convention 108, we could have in Tunisia the whole privacy framework installed together with independent supervisory authority, data subject rights, and direct enforceability for data processing for the purposes of national security, for instance, which GDPR or the directive will not be able to do. So basically that we end up here with a lot of questions, but some ways and avenues forward.
Good, thanks. Any comments on this topic? Any tweets? Sure.
Well, in our group was also briefly mentioned what impact that the Convention 108 might have on national legislation of non-EU countries, and it was said that the fact that the modernized Convention 108 is a binding instrument on countries in Europe that are outside the EU, this may trigger a wave of national legislation on data protection in exactly the non-EU states, which will then bring a more or less common level of data protection throughout Europe.
Which gets us back to the initial question of can it become a standard, a global standard to some extent, right? Good. Any other comments? Running through the questions at the beginning which we had, I think most of them, but you can correct me if I'm wrong, or probably those of you that asked the questions were to some extent touched upon, if not responded, probably not responded. The only one that remains is why aren't we ready for the GDPR, but we are not going to mention that one. And at the end, to close, we have a couple of messages, I think, from Claudio. You're there. You have a mic. So, yeah, he's going to read the messages, and if anyone has anything against the message, let us know. Otherwise, I think we can consider that we agree. Claudio.
Did we have 7 groups or 8? It was not possible yet to summarize them all, but I try to get a grasp of each one in the following messages. And I ended up prioritizing my group because of the obvious fact that I followed the discussion, right? Social media platforms concretely bring much more people into an environment where privacy and data protection are relevant, but the necessary public capacity building and awareness initiatives are not yet in place or widely known. The balance between freedom of expression and the protection of personal data seems to have been adequately addressed through the public interest exception, but objective mechanisms and tools to achieve this balance are unclear and not yet in place. Resources for local data protection authorities are scarce. This will be an obstacle to implement GDPR. GDPR rules are clear, but its implementation is a common problem for all countries, not just a few. There also needs to be awareness of new technologies and business models and how GDPR can be applicable in practice. The actual empowerment of the user vis-à-vis the new approach to the notion of consent is still highly uncertain, and one of the main concerns concerning the implementation, there is too much concern in there. We'll work on that. It is necessary to determine if decisions that were implemented before the GDPR are still a basis for transferring data abroad until they are revised again by the Commission.
Thanks, Claudio. Any major objections to any of those? Seems quite reasonable. Yep. Peter.
Of course, not an objection, but maybe a question. Wouldn't we want to make a small reference to Convention 108 as it was discussed, and can, I mean, if you don't have very much strong feelings against it, can alleviate some of the mystery for coming from GDPR for third countries, as we are currently.
Claudio, you can add that.
Sorry, I didn't.
Oh, we can even. You want to repeat? Or
for our.
You can do it afterwards. Yeah. Okay. Good. Okay. Yes. Nigel, you wanted something to add, or? You want to add?
Basically, it's what I said before. Indeed, there's no bullet now on that. Would we want to include a bullet on key messages?
It would be nice, yeah.
Okay.
It was the only one I didn't have any.
I can help you. I took a lot of notes. It's basically what I mentioned before.
No problem.
Okay, so you can work on adding that one. Good. Okay, we're close to the end. I mean, lunch is outside. At the end, I just have to mention a couple of names that contributed to this session, basically in planning, and that we owe all the thanks for the session. Valentina Pavel, who couldn't make it to be with us in Tbilisi. Ani Nozadze, I'm not good if I'm pronouncing well. Kati Kochladze. Right? Adriana Minovic, Andrea Rusu, and Oksana Prichodko, Farzanek Badej, and Rainer Roldbot from EuroDiG Secretariat. And of course, all of you for coming here and having a great discussion. Thank you for joining us. See you somewhere around for lunch. Thanks.